Yes, Mr. President.
May I pick up on 2 points raised during the course of my submission this morning? First, relation to management fees. The best evidence that I can show, the best document I can show, of course, is in Core Bundle 2, tab 15, page 400. Schedule B to the Defendant's Agreement Petition. It sets out total management fees paid between 2011 and 2018. By reference to a particular asset, so some asset management fees. There's also recovery service fees in the penultimate column. And on the basis of the judgment, what appears to be the case is that management fees were agreed independently as a result of negotiations with the family, and that judgment, phase 2, paragraph 117, little c, that's core 1, tab 9, page 148.
Sorry, 117C, did you say?
117c. And that said that there were no guarantees the defendants would be able to secure separate remuneration for the management functions in relation to assets not sold. They required negotiation of individual management deeds with the family. But from my analysis on the basis of bundles, that's the best evidence that I can put forward at this stage.
Do these schedules give us the expenses as well?
So, yes, my lord. And so, for example, if one goes to 419, one sees expenses at 41.
Thank you.
Obviously, this was material that the judge looked at in detail, and is part of the judgment that, mercifully, I not having appeared below, and this court not having to deal with issues not, I suspect, addressed the second half of the judge's judgment in any great detail. Pausing there, the task that was confronting the judge was obviously a huge one, both in terms of identifying the trees, but also then working out what would needed.
Sorry, what page were you referring to with the expenses?
Sorry, 41, my lady.
421.
Has some response to expenses in respect of and that's part of the summary of presently accountable expenses and expenses. So the second point that I wanted to pick up on was my Lord Justice Popplewell's question to me as to what evidence could I put before this court now to show that the ERSA only came to our attention during the course of these proceedings. I'm not able to point to witness evidence, but I am able to point to submissions in the same bundle. Tab 16. We have the Claimants re-amendment section. Court please turn to page 440. We see the pleading in relation to the ERSA. And this comes under the heading paragraph 5.3. There are concerns about the defendant's disclosure. Historically, in the court we've seen that that's one of the issues that the judge had to look at. But for our purpose, we can see the ERSA is illustrative of the problems as to disclosure. It's plainly a fundamental document which defendants must have been well aware. On several occasions they asserted there was only one agreement, and it was between the fourth defendant and the family. When they were ordered to disclose it, it emerged, so the word emerge is certainly consistent with it being new, and this was a document that was signed by a statement of truth. It emerged that there was no such agreement, and there was indeed several agreements involving different entities. The main agreement, the ERSA, was then disclosed with extensive redactions. Those redactions were challenged and the fuller version was disclosed. Even in that version, a number of clauses, including 4, were redacted. When an unredacted copy was disclosed as part of standard disclosure, it emerged that clause 4 contained an indemnity of the family, which made clear that the draft of the agreement recognised the risk of claims being brought by the claimants in respect of the defendant's provision of the recovery services, inconsistent with the case the defendants were then advancing. The claimants had never had any such rights. That's as far as I can go, I think, on the basis of the material before the court.
Thank you.
Then I'm going to our appeal. So chapter 3 in my submissions. In the claimant's appeal, the claimant seeks to challenge the judge's findings that the defendant should be entitled to receive a 25% equitable allowance. And in monetary terms, that equates to $44.69 million US. And in short, we say that it was wrong in principle and contrary to the decision of this court in Gray. And our grounds of appeal identify 2 particular vices. No need to turn them up, but they are in Core Bundle 1, Tab 4, page 81. And the 2 limbs are, we say first that the judge was wrong to hold that the defendants were entitled to an equitable allowance on a basis for which they'd not argued, in support of which they had adduced no evidence. And the second limb is that we take issue with the particular indicators relied upon by the judge for the purpose of arriving at her 25%. Now, the defendants contend that this is a narrow ground of appeal. They assert that we don't suggest that the judge applied the wrong test as to whether or not there was an allowance, or that there was any principled reason why the defendants were barred from or otherwise not entitled to an allowance. We say that's not an accurate characterisation of our appeal. We do not simply take issue with the quantification of the allowance. As our grounds and our skeleton make clear, we say that it was not legally open to the judge to reach the conclusion that she reached, or to grant any equitable allowance, once she had correctly decided that the allowance sought on the pleaded case was not made out. And we say that that is clear from paragraph 1.5 of our grounds of appeal. And having said that we shouldn't look at it, perhaps we should just very briefly.
Yes.
So that's in Core Bundle 1, Tab 4, and our grounds are at page 81. And in paragraph 1.5 we say the judge should have adopted the approach adopted by Aspin, J and Gray, and subsequently endorsed by the Court of Appeal. In the absence of sufficient evidence as to the value to be attributed to the work done by the defaulting fiduciary, Aspin, J decided to make no allowance. The Court of Appeal upheld that decision, noting at paragraph 239, a claim for an equitable allowance should be in principle be pleaded and supported by evidence in the usual way. The fact that it is a form of equitable relief does not authorise or require the court to embark on a roving commission to achieve a just result.
Well, that's a point on the evidence, isn't it?
Well, my lord, no. With respect, we say that it is the approach that in principle should be adopted, and in 1.4 the judge erred in adopting the approach that she'd done because the defendants had not argued for an allowance based on the market value of their services, no disclosure evidence had been given in relation to that issue, and no submissions had been made about it. So what we say is, in circumstances where the judge did not have disclosure, did not have evidence, did not have a pleading as to the market value of the services, she should have adopted in principle the approach adopted by Aspin, J and Gray, and she should have given no allowance. And there is a need in principle, we say, to plead the claim for an equitable allowance and support the claim with evidence in a proper manner. And I'll show the court the pleading in a moment.
Probably expert evidence, you would say.
Yes, my lord. Because otherwise, how is one going to determine what is fair remuneration? What is reasonable remuneration? And the defendants chose to adopt a different approach. Now, again, show the approach that the defendants chose to adopt in a moment.
If she's going to adopt a percentage, you probably would need some sort of expert evidence as to what a market rate would be for these sort of services?
Absolutely. I mean, there's two parts to it. The first part is a percentage appropriate of profit at all? The second part is, what is the percentage? And the highest the defendants can go is to show that in the past, they independently have been able to be offered, on an understanding basis, not an agreed basis, some percentage of some element of the profit, query exactly how that would be calculated. No evidence whatsoever supporting the 25%.
There'd be no discussion or applications in relation to expert evidence.
There were lots of categories of expert evidence.
On this issue?
On this, no. Because of the way in which the pleading is put.
But can I just be clear what the scope of the dispute is? You say not pleaded and not supported by evidence for the basis which the judge adopted. But if you're wrong on that, you're not saying, for example, that she was wrong to treat this as a case which, within the broader principles in grey, was one in which an equitable allowance could be made, or if you're wrong on evidence and pleading, that 25% was outside the range that was reasonably available to her.
And with respect, I do say that the latter two things, because in circumstances where the focus needs to be on the exceptionality of the test to get an equitable allowance, when one stands back and says, in the absence of the evidence, in the absence of the materials, then there was no basis on which she could exercise her discretion to decide 25%.
No, I'm putting to you the hypothesis that if you're wrong about pleading and evidence, you're not independently then challenging the judge's decision that it was a case that fell as a matter of principle within the grey principles in which an equitable allowance could be made.
With respect, actually, that must be right.
And equally, if you're wrong, I know you say you're not, if you were wrong on your pleading and evidential point, you're not saying that her 25% was outside the range of the discretion that was open to her.
I say, how can one get to a range of discretion? And to that extent, one is then back into the realm of evidence and material, because I do say that factors that she relied on are not ones that are sufficient to justify the 25%, and that's ground 2 of our appeal. So ground 1 looks at the broad approach, and ground 2 in paragraph 2 looks at the factors that she relied on and seeks to challenge why those factors are not sufficient.
Yes.
So, to some extent, I'm in the realm of saying exceptionality sets a high threshold, but the factors that she relied on were not ones that were justified on any view. Against that background, I propose to take my submissions in 4 parts. First, I'll deal with the law, then I'll deal with the nature of the defendant's case on equitable allowances, then I'll deal with the judgment, and then I'll deal with my submissions. On the law, there are in effect 3 elements to the legal background. The first relates to equitable allowances. The second relates to the role of the court when adjudicating upon the issues that the parties raise at trial. The third relates to the role of this court in examining a decision by the first instance judge in relation to an equitable allowance. And I'll take them in that order. In relation to the law on equitable allowances, we've set that out in some detail in our skeleton argument in paragraphs 11 to 15. And I don't intend to repeat myself as to what we said there. We cite 2 cases in particular. We cite Gray in the Court of Appeal at paragraphs 209 to 211. And no need to turn it up. I just want to make one short submission in relation to Gray in the Court of Appeal. We submit that the requirement for there to be exceptional circumstances in order to grant an equitable allowance, and for the discretion to be exercised sparingly, operates materially in respect of 2 elements of the special allowance, equitable allowance claim. First, those principles operate on the decision to entertain granting an allowance at all. Second, they inform the nature and quality of the evidence that must be deployed in support of the pleaded allowance. Why? Because the allowance should only be granted sparingly, only in exceptional circumstances. In order to satisfy that test, both limbs need to be engaged with by a defendant on whom the onus lies to show that the particular equitable allowance that they seek is indeed appropriate. Those principles, we say, the need for it to be sparingly exercised in exceptional circumstances, form the framework within which the court decides whether or not the allowance sought by the fiduciary should be awarded and how much that allowance should be. We say we get that from Gray in the Court of Appeal. The second crucial case, again, which we cite in paragraph 11 of our skeleton, is Guinness and Saunders. Again, there's no need to turn it up. It's an Authorities Bundle 2, tab 12, and the court will be well familiar with it. And I've already made submissions in respect of it. But the core requirement that Lord Gough identifies is the stringency of the core requirement. Any exercise of the equitable jurisdiction to grant an equitable allowance cannot have the effect of encouraging trustees in any way to put themselves in a position where their interest conflicts. And as I submitted yesterday, there's a high degree of absolutism about Lord Gough's approach. Indeed, Lord Templeman uses language that is akin to that of Lord Gough. He does that at page 694, B to C. Phipps and Boardman decides that in exceptional circumstances, a court of equity may award remuneration to the trustee. So we say Guinness and Saunders provides an important touchstone when assessing whether or not the evidence put forward by the fiduciary is indeed sufficient.
What was exceptional about the circumstances in Phipps and Boardman in which an allowance was made?
So there, as I understand it, was because there was no form of wrongdoing on the part of the trustee. He had done his best to tell everybody what was happening. He didn't tell one of the beneficiaries and didn't get informed consent.
So moral obloquy of the breach is a relevant factor.
Well, the nature of the breach may be relevant when working out what the allowance should be, not necessarily what the account of profits should be. The fiduciary shouldn't be punished for the moral obloquy because it's not a question of punishment. The degree of punishment that is necessary, or the penal nature, comes from the fact of the account itself. But what the court is entitled to do when looking at equitable allowance is to say, where are the equities in this particular case?
And in deciding where the equities are, the culpability, if I can put it in those terms, of the behaviour that constitutes the breach is a relevant factor.
That I accept. And
I thought you were submitting the opposite yesterday,
well,
but I may have
no, Your Lordship is right. I did submit that yesterday, and I think I probably have to modify it in this context, in that what is clear from certainly the House of Lords in Boardman and Phipps is that where a fiduciary has, to the external commercial world, done nothing wrong and has done the best that they can, then some form of equitable allowance may be appropriate. The cases distinguish the situation where the fiduciary has done something wrong for the purpose of determining an equitable allowance. But to that extent, moral culpability may be different from the position of the fiduciary because one's looking at the breach itself rather than the nature of the conduct of the particular fiduciary.
Yes. And the other side of the coin is that moral culpability seemed to be the ground which Mrs. Justice Asplin adopted in Gray, which was upheld in the Court of Appeal, despite her other ground in relation to her absence of evidence.
The other important thing to bear in mind, both in relation to Boardman and Phipps and indeed O'Sullivan, is that in many cases, the question of whether or not an allowance should be given is taken in principle separate from the amount of the allowance. So in Baldwin and Phillips, the decision is from the House of Lords, in principle, that should be appropriate to have an allowance. Here we have the rolled up nature of the hearing, where the allowance, both as to principle and amount, is being heard and determined. What we say that indicates is that where the court is being asked to do the rolled up exercise, the tests of exceptionality and the test of sparing use are particularly apposite, because there the court is looking at, in the round, the question of how much, if at all.
Are the two questions not bound up together? The mischief at which this is aimed is the deterrent element. Fiduciaries mustn't be able to think they'll get away with it. The deterrent element is different depending on how much the equitable allowance is. If the fiduciary is going to essentially get all he would have got anyway, there's no deterrent. If he's only going to get 10% of what he would have got anyway, then that might easily meet the mischief at which this is aimed. So that the exceptional, unusual circumstances test needs to be applied, doesn't it, to the question of what equitable allowance, if any, should be made, not in two stages. Do you get over a threshold, and then if you do, how much?
In a rolled-up case such as this, I completely agree. It's being applied at all stages of the assessment. In some cases, it may be decided actually just on the basis of the first stage alone. So in Baldwin and Phillips, it would have been open to the court to say, this isn't, on all we've seen, exceptional enough a situation for this sparing use of this jurisdiction to be used. So we refuse in principle, irrespective of how much the trustees might get, or the fiduciary might get, on any examination as to allowance.
I'm not ruling out that when I say if any, it may be a case where you say shouldn't get any, but the two are rolled up together. And I think what I was putting to you, and I think you were accepting, but I'm not entirely sure from the wording of your answer, is that the test falls to be applied to the question what equitable allowance, if any, should be made, not stage one. Are the circumstances exceptional so that we decide whether there should be any allowance? And then only if you get over that hurdle, stage two, what should it be?
Yes, I don't say what the latter point that your lordship put to me.
Thank you.
But what I do say is that the analysis of deterrence, the analysis of sparingly exercised in exceptional circumstances, applies to the entire question. Now, one can, as I suggested earlier on, winnow that out into two ways. To say it applies both at determining whether or not any allowance should be granted, but it also then applies as to the amount. So I think I am agreeing with your lordship, but all I'm saying is conceptually there are the two elements to it. Absolutely accept that they will be taken as one overall conclusion in circumstances where it's a rolled up hearing such as this. Now, in relation to Gray, my learned friends say that that is a case where there is no statement of principle. And we disagree. And if my lords could take up, and my lady could take up the decision in Gray, it's in Authorities Bundle 3, tab 28. Paragraph 239. We say this is a clear statement of principle. It's a statement of principle, albeit strictly obiter, in circumstances where they say it's unnecessary for us to go to consider Appellant J's second reason for refusing to make an allowance. But we would merely observe that she cannot, in our view, be criticised for confining her attention to the claim for an allowance as it was actually presented to her and argued at trial. Mr. Dutton seemed at times to suggest in his oral submission that the judge was under an obligation to consider the question, if necessary, of her own motion, regardless of how it was argued before her, and that this court too should, if necessary, adopt a similar approach. If that is what Mr. Dutton intended to say, we do not agree with him. A claim for an equitable allowance should in principle be pleaded and supported by evidence in the usual way. The fact that it's a form of equitable relief does not authorise or require the court to embark on a roving commission to achieve a just result, nor does it mean that a judge can fairly be criticised for not proactively seeking alternatives to the allowance claimed if the judge considers it excessive or wrong in principle. There may occasionally be cases in which it's appropriate for a judge to take the initiative in that way, but we do not consider the present case to be one of that character. So, pausing there, what the court is saying is that there needs to be pleaded and supported evidence. In some cases, there may be the need for a roving commission, but in that case, occasionally. But we say in this case that was not one. We say that that was not the approach that the court should have adopted. Indeed, that was the approach that the judge said was not going to be operated by, and I'll show the court the judgment in a moment. We say that, as a matter of fairness, we should have been given notice of the fact of this particular form of claim, not least because, at its core, the analysis should have been the fair remuneration or the market value of the services that were in fact provided. So, my lords and my lady, that's all I think I need to say in relation to Gray. The other case on which we rely is the case of Innovative, which is a decision of the High Court of Singapore. We set out our references to that in our skeleton argument, paragraph 15. The authority itself is in Authorities Bundle 4, tab 36. Perhaps we can just look at that very, very briefly. This is a decision of Ang Cheng Hock J, where he adopts what we say is an orthodox approach to the granting of an equitable allowance. One sees that at paragraph 131 of the decision, at page 1153.
So sorry, could you give me that reference?
Yes, sorry, it's 1153, my lord. This is relevant for a number of reasons, but first one looks at 131, where we see the orthodox approach towards the Guinness and Saunders type position. Over the page, the defaulting fiduciary would have to establish that it would be inequitable for the court to order him to account for all his profits. In assessing whether an equitable allowance should be awarded, the court would examine whether the fiduciary acted in good faith and honestly. And then 132, applying these principles, I find that this is not an appropriate case for the court to grant any equitable allowance to the first defendant. I fully appreciate that the first defendant had marshalled much of his time, effort, skill and experience into converting the business opportunity that he was presented with into the completed project. And then one cuts down, put simply, the first defendant was exercising his best efforts to ensure that he could maximise the benefits to himself from this opportunity. If he's awarded an equitable allowance and permitted to effectively retain some of the profits from the project, that appears to me to be contrary to the principle that fiduciaries who misappropriate business opportunities that rightfully belong to their principals should be compelled to disgorge all the profits they've made from that opportunity, even if this might result in a windfall. So we say that both of these cases, Innovative and indeed Gray, are cases where the court looked at the material that was put forward and decided on the basis of the facts whether or not to allow an equitable allowance.
Could I ask you about 132 though? In what circumstances will the fiduciary not be seeking to maximise the profits from the opportunity? I'm not sure what distinguishes this from any other case.
I think what the judge was meaning, my lord, is that simply saying, I spent a lot of time, effort and skill on this particular exercise is not sufficient in itself to lead to an equitable allowance, because in most cases that will be the position that the fiduciary would adopt. what it's looking at is the exceptionality and the sparing use of the discretion. So mere expenditure of time, effort, skill and experience is not going to be sufficient to bring the equitable allowance into play.
Not even providing a guarantee of 159 million.
On the facts of this case. On the facts of this case, no. Apparently harsh results justified by the deterrent effect. So my friends in relation to Gray and in relation to innovative seek to say that there are examples where there was no evidential basis at all for the conclusion that the court reached. With respect, we say that's not right. Innovative looks at a large amount of evidence as to what should be the appropriate allowance, if at all. Similarly, in Gray, there was a factual case that was specifically argued in support of a specific figure of £1 million and supported by evidence from a witness of fact. That's at paragraph 198 of the decision. The court looks at the evidence and rejects the evidence of Mr. Ward and reaches a conclusion that on the basis of the material put forward by the defendant, the equitable allowance wasn't made out. So that's where evidence was in fact grappled with. Our case, we say, is different. My learned friends rely on three particular cases in support of their case. The first they rely on is Accedia, and that's in Authorities Bundle 3, tab 21. I'll leave Mr. Burt to show the court the judgment insofar as he wishes to do so. My point in relation to it is, in that case, there was clear evidence as to the market rate for commission in that type of art deal. And one sees that from paragraph 95. So the court decided on the basis of the evidence that it had before it what the market rate was and set that at 10%. No assistance in this case in circumstances where the vice on the defendant's part is not to put any evidence at all, or indeed not to put a pleading forward.
So I missed which case and which tab.
I'm sorry, but that's Accedia. Accidia. That's Authorities Bundle 3, tab 21. It's the case about the art dealer.
Thank you.
And an undisclosed commission. The second case, again, that my learned friend relies on, and again I'll come to it in reply if need be, is Kingsley IT Consulting in Macintosh. That's in Authorities Bundle 2, tab 19, page 559. That's a judgment of Mr. Malshinson QC sitting as a deputy. The case was decided before Gray. It's unclear, and my learned friend accepts this, as to how an allowance of £2,500 or £3,000 a month was set. But what appears to be the case is that the judge sets the allowance by reference to what the parties had agreed in the past as £2,000 as reasonable drawings. So there was there evidence of what would be reasonable. No finding in this case on that. But ultimately, we would say in any event, it's a first instance decision that is limited in its rationale, in its reasoning, and it isn't ultimately.
You say no finding in this case. There was a finding, wasn't there, that about 50% is what the parties would have agreed.
Not that it was reasonable, my lord. So we say, in circumstances where the test for the court, in a case such as this, is what is the fair value, what is the market value, what is reasonable remuneration. The court can't just start with what the fiduciary would have got had they been loyal and scale it down. But that, in effect, is what the defendants ask the court to do. I accept Macintosh looks odd from that perspective, but it's a first instance judgment, low rates, unreasoned, pre-Gray.
Well, you say it looks odd. I mean, it might be said against you, perhaps it will be, but it's rather odd to submit that what these parties had agreed by way of common understanding is what would in fact have happened going forward, and to suggest that isn't a yardstick which one can take as to a reasonable level of remuneration in this particular market?
I wouldn't, in principle, say that it's a factor that needs to be excluded entirely from consideration. But the question is, in any particular case, what is the market value? What is reasonable remuneration? And
but often what parties have agreed to pay for the actual services is probably the best evidence of market value.
It may be, it may not be, but it may also be in circumstances where what is agreed is on the basis of loyalty. One can't use that agreement as the mechanism to value the services themselves.
But also the 50% was agreed on the basis that, as I understand it, the defendants wouldn't necessarily be providing all the services, nor would they have been taking any of the risks, financially. So, in fact, 50% you might say the starting point would be more than 50% before one then looks at any discounting factors.
But I think what this, from the claimant's perspective, what this analysis shows is what a dangerous place it is to seek to rely on what the parties may or may not have agreed in particular circumstances, or what they may have understood to be the position in particular circumstances. And the court may decide that that evidence is the best or a clear indication of market value. And to some extent, that's what happened in Excedia, where the agreements that had actually been concluded were seen to be consistent with market rates. In circumstances where what the parties have agreed may or may not be consistent with market rates, the court will need to decide whether or not that is a document or a factor that should be taken into account at all.
Well, what's the market in this case?
Well,
the market is recovering assets for the Badbury family. Pretty much one-off element. But what is said against you is this is in the context, in the private equity context, in which such remuneration would typically be by way of a share of profits, rather than lump sum for time worked and so on. So if the market is limited and we have an agreement as to what would have been the profit element for the specific market, what other evidence could there be of market? What expert evidence are we talking about otherwise?
What we would say is, firstly, this isn't just a private equity model. But even if it was a private equity model, there's no evidence to show that 25% is the appropriate rate that a private equity model would generate. Then, if it's not a private equity model and also has elements of recovery services, if the case had been put that this was the market rate for this service, then the parties would have given thought as to which expert could give evidence. The court would want to entertain evidence as to whether or not there were other people who provided recovery services to other well-established individuals, and the rate that would be charged in respect of the services. Indeed, there's evidence before the judge that other people tried to offer services to the family in respect of recovery services, but their services were declined. So it's not that this is a singular piece of business where no market value could be established, but even if it is the case that there's no market value or no other one else in the market who's provided, the question for the court is what's reasonable remuneration? And, well, we would say that is the proper case that could have been put, but that's not the way in which the defendants put their case. They didn't seek reasonable remuneration based on market value. They sought remuneration, an equitable allowance, on the basis that they had unique skill or that they'd increased the value of the assets. And the judge rejected those cases. Having rejected those cases, the answer should have been nothing. Instead, the judge undertook a roving commission. The third case relied on by my own friends is the case of Fischel. That's a decision of Justice Elias at first instance. That's call 1 Authorities Bundle 2, tab 14, page 384, we say that...
I'm so sorry, I was making a note. Which
I'm
is
sorry,
the third case?
that's official. That's the judgment of Miss Justice Elias at first instance, Authorities Bundle 2, tab 14, page 384. Again, I'll leave Mr. Burt to develop the case insofar as he wants to. What we say about it is that it is quite a different case. It's quite a different case in circumstances where the agreement allowed for, as between the fiduciary and the between the fiduciary and the beneficiary, for a particular sum to be paid in particular circumstances, and in circumstances where the agreement subsisted, there was no problem in principle with allowing the allowance to reflect what he might otherwise have been able to do. Again, we say it's a first instance decision and doesn't impact on this case as to the setting of the reasonable remuneration by fair market value. Against that background, I'd like the court to look at the judgment itself, which is in Call Bundle 1, tab 9. One can pick it up, please, at paragraph 174. And I'd like to start, if I may, with paragraph 266, where the judge makes a finding, not in the context of the allowance in particular, but in relation to the account in general, that it's not a free-for-all. But then if one goes on to paragraph 366, one sees how she deals with the allowance for skill. That's page 193. And she sets out in that paragraph a useful extract from Dr. Matthew Conaghan's article, or one of his many articles in relation to this topic. And I'd like, if I may, to pick it up at page 194, the paragraph that begins, if granted. If granted, the allowance covers reasonable or fair remuneration for the work done in generating the profit, rather than an estimate of what the particular defendant could have negotiated as remuneration for that work. And we say that that's right. And if the fiduciary could have negotiated a better rate of pay for the work which generated the profit, the failure to take that step is the fiduciary's own, and so does not further diminish the amount of the profit for which he or she must account. We say there are good policy reasons for looking at matters objectively. If the fiduciary could have negotiated more, then it's their fault that they can't get it. Then Dr. Conaghan looks at O'Sullivan and looks at the profit element in that case and explains the profit element there not by reference to a share of the profits, but by reference to the profit costs that a solicitor might otherwise be able to charge a client. So O'Sullivan is not authority for the proposition that a share of the profits would be appropriate, as appears to be suggested in some of my learned friends' written materials. But it is clear that the reference to profit by Lord Justice Falk is about the profit costs that a solicitor would be able to usually recover. So not just covering expenses, but also an element that reflects the professional skill and labour of the fiduciary. And that's in the particular facts of O'Sullivan and the particular circumstances of that case. Then if one cuts down to just about 7 or 8 lines from the bottom, this approach anchors the decision as to the amount of the allowance to a reasonable sum for the work which was needed to generate the profit, bearing in mind relevant market conditions, rather than it being a free-floating discretion to divide the profit between principal and fiduciary in some arbitrary proportion. And we wholeheartedly endorse that view. And with all respect to the judge, that is what she failed to pay attention to when she came to look at the discretion. She did use a free-floating discretion, and she did divide the profit in an arbitrary proportion.
But it's a distinction without a difference if you're in a market where fair remuneration is measured in the form of a share of profit, isn't it?
Well, not, my lord, where one's saying 25%. because there's no evidence at all to show that 25% is the reasonable remuneration for the services that these defendants provided. It is a figure that is absolutely plucked from the air. I accept, and I hope I've made that clear, that I accepted earlier that some share of profits may, in some private equity situations, be the norm.
No, but what the judge did in this case was say that 25% was less than reasonable remuneration, but it was going to come down to 25% to take account of the deterrent element. Well, that is what she did? Isn't it?
Well, but how one gets to the 25% is entirely unclear on that analysis.
We're not talking about apples and pears here, but the percentage commission that somebody would get would be a percentage of the recoveries.
In some circumstances that may be the case, but in this case it's the profit that then is, what is said is the profit that is then accrued by the person undertaking the recovery services.
It's the
In whatever way has been agreed.
Then that wouldn't be somebody undertaking recovery services. That would be somebody undertaking recovery services on behalf of somebody providing recovery services. It's a slightly more complex situation, isn't it?
Yes, certainly. The basis on which one seeks to make a private equity type analysis is unclear to me. It may be that what is said is, in some private equity situations, the carried interest will be the profit above a certain value. And it may be being said on the part of the defendants that this is precisely such a situation, that they were entitled to carried interest above a certain amount, where the assets recovered were for a certain amount. And to that extent, they say, a percentage is the way in which these sorts of figures are arrived at. But we say that that doesn't answer the question of what is reasonable remuneration, fair remuneration for the services that were in fact provided.
Just to be clear, what we're talking about, the hypothetical we're considering is what the defendants would have been entitled, what the market would have been for services provided to your clients of recovering the money they're accounting to you for.
Yes, absolutely. And the suggestion that there's some assessment of that value out of what the defendants themselves managed to achieve from their agreement with the family is, we would respectfully submit, not a valid or safe place to start. Just continuing in the judgment, one comes to 369 where the court looks at O'Sullivan, and I've already made submissions in relation to what is meant by profit in that paragraph, or sorry, in that judgment. If one looks at what the court says there, once it's accepted the court can make an appropriate allowance, do not see why in principle it should not be able to give him some part of the profit of the venture if it was thought that justice as between the parties demanded that. To give the fiduciary any allowance for his skill and labour involves some reduction of the profits otherwise payable, and the business reality may be that the profits could never have been earned at all as between fully independent persons except on a profit-sharing basis. But be that as it may, it would be one thing to permit a substantial sharing of profits in a case such as Phillips and Boardman, where the conduct of the fiduciaries could not be criticised, and quite another to permit it in a case such as the present where, though fraud was not alleged, there was an abuse of personal trust and confidence. And it's on that basis the court then reaches a finding as to the profit element in the solicitor's costs, and one sees that at the end of that first extract, the first paragraph of that first extract. And then one looks at the second part of that extract. In my view, this would achieve substantial justice between the parties because it would take account of the contribution made by the defendants. It would not take full account of it, in that the allowance would not be at all as much as the defendants might have obtained if the contracts had been properly negotiated between fully advised parties. This, with respect, goes to my Lord Justice Popplewell's question to me, is it not appropriate, in effect, to say it would have been 50%, we just now reduce down? The court, in this case, is adopting not that approach, but is rather saying what would be the reasonable remuneration, what would be the profit cost that solicitors would normally, or the type of profit cost that a solicitor would normally get. That will be below the amount that might have been agreed, but it is not a question of scaling down to reflect the fact that this was not able to be achieved by the particular fiduciary concerned. We say that the court then lost sight of the deterrent effect, lost sight of the exceptional circumstances, lost sight of the sparing use of the allowance when the court came to look at the ultimate conclusion. One can perhaps see the beginnings of that losing sight with respect to the judge in the judgment at paragraph 372 on page 196. So she concludes there is authority which supports the proposition put forward by Professor Conaglan. An allowance may be made in equity for the skill and labour put in by the defaulting fiduciary, and that while the court will look carefully at the circumstances before granting any such allowance, cases where the work done by the fiduciary would otherwise have to be done by another, and or the work done has benefited the property which forms the base of the account, are ones where such allowance may be appropriate. Now, in principle, that is not objectionable, save insofar as it doesn't take into account the question of deterrence, nor the question of sparing and exceptional circumstances. What she was doing with respect to her was conferring on herself too much of an open text of discretion. And a similar trailing of the error we would submit, one can see in paragraph 423 of the judgment, where she says, and this is in the context of the profit sharing agreement, quite aside from the question of whether it is contingently relevant, if I prove to be wrong on the point, it has seemed to me that the existence of such an agreement might well be relevant to the question of the quantification of any allowances to skilled. I therefore deal with this point below. Now, we don't say that in principle it could never have been a factor that could have been taken into account, but it would have to be taken into account by reference to evidence as to market value.
Sorry, why do you accept that it was a factor that could be taken into account?
Because, well, in some circumstances it may be. The court may want to look at what the parties had agreed between themselves in order to try and work out what the market value might be, to test the evidence as to market value by reference to what the parties had in fact agreed.
But you're effectively saying that you can't look at that in the absence of other evidence of market value. You can't look at that.
Absolutely. Absolutely.
So in a standard sale of goods case where the market value is taken in the absence of any other evidence to be the sale that was in fact conducted between the parties, that's wrong in principle, is it?
In sale of goods cases, very different, my lord. This is a case involving a burden on the defendant to justify an equitable allowance.
No, but you're making a narrower point that there was some evidence which could be taken as support for what the market rate was, but as my lady says, your case is that there had to be other evidence. Leave aside the pleading of it. There had to be other evidence before that could be taken as conclusive.
I wouldn't say that this is evidence of market value.
Well, why are you accepting it's relevant then? Why is it relevant?
Because in circumstances where the court then wants to work out what the reasonable remuneration might be, or the market value might be, it might, in some circumstances, be appropriate to test by reference to the evidence that it has otherwise received what the parties have in fact agreed. What would be wrong in principle is to set the rate by reference to what the parties had agreed, but I'm not ruling out the possibility that in some cases it might be appropriate to take into this account. Now, if your lordships are not with me, or lordship's not with me and says, no, the rule in equity needs to be firmer, I'm obviously not going to seek to dissuade the court from adopting that approach. What I'm seeking to do is to say, I don't need to go to that extreme position, because in some cases, what the parties have agreed between themselves may be material that the court can rely on. In this case, it wasn't, because of the way in which the case was put. And I'll come to that in a moment. Can I just deal with my second and third points as to the legal background very quickly. The first, or the second point that I make relates to the role of the court when adjudicating on issues raised by the parties. And that we rely on Al-Medini. That's in Authorities Bundle 2, tab 17. And we've set out the relevant principles in paragraphs 16 to 18 of our skeleton. Similarly, we rely on Sainsbury's at Authorities Bundle 3, tab 27. And we rely on Satyam, Authorities Bundle 4, tab 31. My learned friends seek to rely on two other cases, Dink and Severe. Again, I'll leave my learned friend Mr. Burt to expand upon those decisions insofar as he wishes to do so. The crucial element in Dink is that one needs to identify what the prejudice was. And I'll come on to look at prejudice in a moment. In relation to Severe, the issue is just there was a black and white decision, a binary decision between the parties as to whether or not an agreement was a sham or not, and the judge decided on the basis of the evidence that the defendant hadn't discharged the burden of proving it was a sham, or the party taking it to contend that it was a sham was a sham. Neither case assists overall in the principle that we've identified in paragraph 16 to 18. The third element is that the role of this court in examining a decision by a first instance judgment in relation to an equitable allowance, that's the third legal background. And we say in this case that the power to grant an equitable allowance is obviously discretionary, but we say in circumstances where the discretionary decision maker has gone wrong in principle or has taken into account irrelevant factors, then we're entitled to challenge that in this court, and I will seek to make good our submission that that's what the judge did in this case. It was an error of principle, it was also the taking into account of irrelevant factors. So then the second part of my submissions relates to what was the defendant's case on equitable allowances. And for that, please, could you take up the position paper put forward in this case by the defendants, and that's in Core Bundle 2, tab 15. And one starts with paragraphs 18 and 19 of that document, and that's at page 309 in tab 15. So the plea as to how the equitable allowance was to be granted to them in this case was 18. The defendants are entitled to an equitable allowance. The equitable allowance is to reflect their exceptional deployment of time, effort and skill, an assumption of significant personal and commercial risk in performing the recovery services as set out in section B below. In the context of the private equity business in which the parties were engaged, and in the specific context of this case, that should be calculated as a share of profits after deduction of their reasonable expenses and or a sum representing the consultancy fees, salaries and member drawings paid to the individual defendants. Paragraph 19 specifically, the defendants will contend that it should be at least 50% of the otherwise recoverable amount, alternatively such sum calculated on such basis as the court thinks fit. So the allegation there as to the basis for the equitable allowance was on the basis of exceptional deployment of time, effort, and skill, and the assumption of significant personal and commercial risk.
But the allegation as to how you calculate the allowance on that hypothesis is that the market is one in which it should be calculated as a share of profit.
Absolutely, Model. That's the allegation. But there's no suggestion as to 25%, obviously. There's no suggestion as to how the court should, as in paragraph 19 it suggested it should, calculate such basis as the court thinks fit. Absolutely, I accept that it was an allegation of a profit share. Absolutely, that's the case. But the vice in the judge's approach is to...
Allegation of profit share as being the means by which the market rate is to be decided.
Yes, my lord, in relation to what was said to be in the context of the private equity business, yes, in which the parties were engaged. Now, obviously, the recovery services went beyond the private equity business.
Well, and the specific context of this case.
Yes. My lord, my lady, that's the first limb of the claim. The second limb of the claim comes in paragraph 19A, which is a plea made by amendment the extent of the assets under the ownership, management and or control of the defendants are otherwise within the scope, then the defendants are entitled to an extra allowance to reflect the fact that their exceptional deployment of time, effort and skill and their assumption of significant personal values has resulted in an increase in the value of such assets. So again, there's reference to the exceptional deployment, but in this case it's based on the increase in the value of such assets. And that was a case ultimately at trial that was not pursued. So instead what the judge was left with was a case built on exceptional deployment of time, effort and skill and the assumption of significant personal risk.
Sorry, you're saying the pleading 19A is not pursued?
Absolutely. Now, in relation to the plea at paragraph 18, no evidence of market value was called. We say no evidence of market value as to the amount of any percentage was called. No plea in relation to the amount of market value was made. And that's what one gets from the basis of this pleading. The third part of my submissions relates to the judgment, and we've summarised what the judge said in paragraphs 25 to 27. Your Lordships and your Ladyship will have read the paragraphs in the judgment itself. I'm going to look at the judgment in more detail by reference to the submissions that I want to make, and that's my fourth part of my submission. And we have two submissions to make. The first submission is that the judge was wrong to find that the defendants were entitled to any allowance, given the way in which the defendants chose to argue their case. And in particular, the judge was wrong to award an allowance of 25% in the absence of any positive pleading case, the absence of any evidential case in support of that allowance. And as we've seen, it was based on the pleading on exceptional deployment, no evidence advanced in relation to increases in value. What the judge then did was to look from paragraph 4 through 6 and following at the particular nature of the claim as being put forward, and it's important to turn that up. That's in 411, tab 9, page 208. And she sets out at paragraph 436 the issue that the parties had formulated for the purposes of the trial. And the judge, when inviting the parties to put forward written closing submissions, asked the parties particularly to address themselves towards the list of issues. One can well understand why that would be the case. In a case such as this, where there are a number of disparate elements, disparate allegations, it is particularly important that the parties do then focus on the list of issues, particularly when invited to do so by the judge. The list of issues, as formulated by the parties, was: did the individual defendants bring to the recovery services skills which made them uniquely well suited to carrying out those services, as alleged in paragraph 31 of the defendant's re-amended position statement? Were they entirely dedicated to the recovery services project as alleged? Did they take significant financial, commercial and personal risk, as alleged at paragraph 32A? And then she says, in light of her conclusions about the formulation of the issues, perhaps not entirely apt, that's how she has looked at the form of the allowance that might be entitled, a party might be entitled to receive. However, I shall consider the formulation agreed before passing on to the part which has real potential to impact on the case. And she looks first at the question of unique skill. And she does that in paragraphs 438 and following. And having heard the evidence in summary, she reaches the conclusion that it was not appropriate to attribute any unique or exceptional skill to the defendants. And the court will be able to read for itself these paragraphs, and I'd just like to highlight, if I may, two. One looks at paragraph 444. She says, to the extent that it did matter, that's in relation to the allegation that the defendants fared so poorly in their dealings with the family, she says, disclosed a number of aspects which would have made me unwilling to attribute any unique or exceptional skill to the defendants. both the drafting of the ESA and the defendant's handling of it in relation to termination appeared to verge on the inept. And she gave a number of examples as to why that was the case. The ESA was badly conceptualised and drafted. In paragraph B, they were not particularly able to explain how it worked in practice. Paragraph C, there were not only problems with the ESA, it contained at least one redundant clause. D, while the defendants tried to sell the February 2018 letter as a tactical victory, it appears to have been sent without any proper thought as to just how risky a strategy it was. So they adopted thoughtlessly risky strategies which put them at a disadvantage in negotiations. So one can see why the court reached the conclusion that they didn't have unique skill and expertise. It said in my learned friend's submissions that we, at trial, sought to embarrass them in relation to the negotiations of the ESA by showing how badly it actually turned out for the defendants. The difficulty in this case was, although there was lots of assertion on the part of the defendants as to how much work they did, there was actually very little concrete that one could cross-examine them on. The one piece of material that one did have to cross-examine, and Ms. Fatima did cross-examine the defendants in relation to it, was the ESA itself, and was able to demonstrate that the defendants didn't really understand it very well and hadn't necessarily secured a very good deal for themselves. It wasn't about embarrassing the defendants, it was about proving the absence of unique skill, something that the judge then came to accept. So that's 444. 446, the defendants were also examined in detail on the progress of recovery of specific assets. In relation to this, again, their answers as to their contribution was not impressive. And she then sets out some examples in paragraph 447 to 449. There's no need for me to dwell on them now. The court is able to read them in due course. The conclusion is in paragraph 450. It was accordingly forced in the submission that all three of the individual defendants failed to demonstrate any unique skill. Much of their work appeared to involve very high-level input and iteration of concepts, together with the delegation to others of the day-to-day running of litigation or business. Now, the idea that that would be exceptional, sufficient to bring into effect the equitable allowance, is, we respectfully submit, clear. There's no basis on which, on the pleaded case, the defendants had discharged the burden that was on them to show that they should be entitled to an equitable allowance. That was the end of the defendant's pleaded case. We've already looked at risk, and again the court found that risk was not sufficient to mean that they should be entitled to have an equitable allowance on the basis on which they had pleaded it. So the short point that we make is that, having reached those conclusions, the court should have gone on to find that the defendants had not discharged the burden that was on them of showing what allowance would be appropriate. To that extent, it becomes academic as to whether or not it's a question of should there be allowance at all. What is clear is, on the basis of the facts being put forward by these defendants, they shouldn't be entitled to any allowance. Well, I'm conscious of the time. I'm doing well, but I suspect I will finish just about the time that I indicated, and we've agreed I would finish by 4 o'clock. But now would be a convenient moment to break.
What's raised?
Yes. One.
Okay, oh, that makes sense. Yeah. Yeah, fine.
Courts rise.
Yes, please. So just before the break, I made the submission that what the judge should have done was stop there. She should have examined the defendant's case. She should have rejected it on the basis of the facts that she found. Instead, what she did at paragraphs 4, 5, 6 and following is to seek to say, well, there's not unique skill, but nonetheless there is skill and effort. And she reaches findings of fact as to skill and effort between 4, 5, 6 and 4, 6, 4. And we don't seek to challenge the findings of fact that the judge made, but we do say that from 5, 6, 5 onwards, she reaches the wrong conclusion. And what she does from 5, 6, 5 onwards is to say first that
Sorry, do you mean
465. I apologise. 465, page 214. The question then becomes whether it's possible to ascertain what the allowance made should be. Now, as I've said, this is a rolled up question, but she then says that the defendant advocated a 40% allowance based essentially on the profit sharing agreement. In my judgment, that's the wrong approach. There's no valid, in the sense of legally enforceable profit sharing agreement. The case is cautioned against analysing by reference to what would have happened had there been no breach. And that is good sense, we submit, when one tries to work out what is fair remuneration in respect of these defendants doing what they did. One can't start with the agreement that was agreed, and one shouldn't start there. One shouldn't scale down, not least because the 50-50 agreement, if there was such an agreement, was based on, in part, services that had already been provided between 2008 and 2011 when the relationship broke down. Moreover, when one looks at the agreement at that stage, one bears in mind the judge's findings at paragraph 402 of the judgment. And perhaps we could just turn back to that very briefly. Page 202. At the time of the breach, I was persuaded on the evidence that far from transforming post-breach, what happened was effectively a natural continuation of the work which had been done before, while Mr. Jaffe's view that everything had been sorted out on his watch and that the defendant had simply been left to pluck the right fruit was somewhat of an overstatement. The reality is that by May 2011, the main areas were either set fair or well set up for future resolution. So the idea that one uses that arrangement, that 50-50 arrangement, to put it in the way that the judge found it, as a basis for scaling down, would, we submit, be wrong. Moreover, we don't read the judge's findings as, in practical terms, a scaling down, either from 50% or the 40% allowance contended for by the defendants. What the judge then did was, in paragraph 466, is to say we've moved from a determined figure based on the past and hypothetical future agreement to a realm where something akin to the Boardman and O'Sullivan approach is to be aimed at. So she's accepting there that there needs to be fair remuneration. The question then is, how does one look at what fair remuneration might be? Boardman and Phillips, we say, is not an example where these defendants are able to look to. Why? Because what Boardman makes clear is that the profit that the fiduciary made was made with the primary interest being to increase the value of the trust fund. That's page 200G of the authority. So Boardman isn't right. O'Sullivan isn't right because it's based on, in that case, as in Boardman, a position where the court was not able to determine whether or not what was being sought was fair remuneration. Why? Because there was no evidence at that stage. Those matters needed to be sent off for a further hearing. So what the judge was not doing was adopting the approach in O'Sullivan and Boardman of then seeking to work out what
fair remuneration would be. Rather, she goes to say, on a roving basis, what does she think the basis should be? And she looks then at what the defendants say.
So I thought you'd started your submissions on paragraph 466 as saying that that was the judge accepting that the test needs to be one of fair remuneration, and then going on to say, but that wouldn't, neither Boardman or O'Sullivan would treat fair remuneration as profit. Have I understood you correctly?
You have, my lord. I'm sorry, I took it too fast. The first point is by saying that the approach adopted by the defendants is not appropriate, of starting with the agreement and scaling down. She's saying it, and you shouldn't look at the past hypothetical future agreement. You should look at something else. What she's saying by something else, she's looking at fair remuneration. And O'Sullivan makes clear that it's fair remuneration. That's the passages in Waller, Lord Justice Waller 312 that I referred to in the course of my submissions this morning. So paragraph 466 does two things. First, it says not the approach advocated by the defendant of scaling down or using the previous agreement as the basis for assessing. Then the second element is she says something akin to the Boardman and O'Sullivan approach needs to be adopted. But in Boardman and O'Sullivan, the court was saying evidence or an inquiry will need to be undertaken to work out what that fair remuneration would be.
In both of those cases.
In both of those cases. So she wasn't adopting that approach. Instead, she says, at this moment, I'm now going to go and look to see what the position should be. And she says in 467, the defendants haven't helped her. And she says the defendants haven't helped her for sound or
That's my
doubtless.
fault. What was she not doing then?
She was not, well, scaling back. She should have said none of this was appropriate because they haven't proved their case. But in circumstances where she then says, I'm not going to do what the defendants tell me to do, I'm going to work out what fair remuneration should be, she should then ask of herself, is there evidence before me to show fair remuneration? Answer, no. Why? Because the defendants haven't put any evidence in to assist me. And they haven't put any evidence in, doubtless for sound tactical reasons. So there's a specific finding that there's a litigation choice being made by the fiduciary not to put the evidence in. That conclusion is not challenged on appeal. And subject to the views that the court ends up taking, as with the defendants' negotiations over the Ursa, that may similarly be an inept decision that the defendants took.
Well, that's the point she's addressing in the following paragraph.
Well, I'll look at that in a moment, my lord, as to the counsel of despair. But if one looks at what the defendants are articulating, they don't seek to articulate what their case is. And indeed, the judge later says that she effectively rejected the case that was put forward. And one sees that in the same bundle, Core 1, Tab 12, page 282. This is the judge's ruling on costs. And in paragraph 28 of the judgment, we see her dealing with the equitable allowance, or rather, one starts it at 27. So far as equitable allowance is concerned, I do not accept that there should be some form of allowance or reduction for equitable allowance. So the defendants were seeking to say that some discount from costs should be made because of their win, as they saw it, on the equitable allowance issue. And the judge says at 28, it was not a case of an entire root and branch resistance. And so far as the defendants are concerned, they cannot say they were successful in the case they advanced, because they were not. Their case was, as Ms. Fatima pointed out, essentially one which is in relation to unique skill and delay. Both of those I have effectively rejected. No argument was made in relation to equitable allowance arising out of the 50-50 agreement. The basis upon which the equitable allowance was found was essentially either entirely or very different from the basis on which it was urged by the defendants. And very little assistance was given to me in reaching that point, as Ms. Fatima also rightly pointed out. So we say, having again reached that conclusion, having reached the conclusion in the judgment at 467 that the defendants had offered no assistance, it was unfair for the defendants then to be able to be given the benefit of the equitable allowance that the judge came to find. And what one sees in 468 is the reason why the judge decides to adopt what we say is a roving commission. She sees that the position that is being adopted by the claimants as a counsel of despair. And with respect, it was nothing of the sort. It was the proper and principled approach to adopt, which took proper account of the burden on a defaulting fiduciary to plead and evidence any allowance that they seek to recover. Now, the fact that the result might now, to your lordship and your ladyship, seem harsh, was a result of two decisions by the defendant. First, their decision to breach the fiduciary duties in the first place. Second, their failure to articulate a clear and evidence case as to the allowance that would be appropriate. So, it is not a reason to despair. Rather, one is entitled to say that the defendants would be receiving their just deserts given the choices that they made. And again, that's where the judge should have stopped. But what the judge instead did in paragraph 469 was to collect a number of what she described as indicators, which point in what she says to be a sufficiently fair and robust direction. Before we broke, my Lord Justice Popplewell suggested to me that she started with the 50-50 agreement and worked backwards. What appears to be the analysis is not that, with respect. What appears to be the analysis is she rejects the 40% allowance sought, and she then uses the factors in 469 alone to determine the amount and the fact of the allowance. And we submit that that was wrong in principle. Why do we say it's wrong in principle? Because we are prejudiced as to that approach. We submit there should have been a pleading, there should have been factual and expert evidence as to, if she was going to undertake a market value analysis, the market value. We didn't adduce any evidence as to market value, nor indeed the defendants. And the expert evidence might well have looked at private equity models, both as to percentages and as to profit shares. It might have looked at the wider elephant, the wider different elements that I've identified earlier in relation to the recovery services, the identification and protection of assets, and litigation support. To that end, not having that evidence means that the judge is left at sea, we submit. She's left at sea both as to the fact of percentage, but she's particularly at sea as to the percentage that she chooses. And what the defendants should have done, if they wanted fair remuneration by reference to market value or the type of factor that I identified in paragraph 469, they should have pleaded it. They should have evidenced it. They didn't. And this court, when bearing in mind the deterrent effect, when bearing in mind the fact that these allowances should be granted in exceptional circumstances and sparingly, should not permit that judgment to stand. Inevitably also, by way of prejudice, there would have to have been focus at moments in time as to what services had already been achieved or what recoveries had already been achieved. So, for example, what was the status of the recovery services in May 2011? Now, I've shown the court already a reference by the judge to the fact that things were broadly set fair, as in May 2011. In those circumstances, was it reasonable then for them to receive 25%? In circumstances where a lot of the work had been done on the watch, where SCPI was in charge of dictating the direction of the services. So that is another element that would have been focused on, not just expert evidence, but also factual evidence as to what was going on at that moment in time when the break occurred. It's suggested that we're relying on hypothesis, but we're not. We are seeking to identify what the market value of the services would be, insofar as that is the touchstone that the judge appears to have used for the purposes of working out what fair remuneration would be. And it's for the defendants to make good their case, to discharge their onus. And we say that they've not done so. So that's why we say the judge's approach in principle was wrong. She should not have found in paragraph 468 that there was a counsel of despair. She should have drawn the line there. That then brings me to my second submission, that the judge's reliance on the 5 indicators was wrong and illogical. And one looks at the individual 5 factors. One starts with the first factor, 1A. The expectation was always that the individual would do the lion's share of the hard work, the recovery service. And we say that has no value when one tries to work out what the value to be attributed to the services would be. The second and third indicators, what are they? Mr. Rudhadze had previously been remunerated based on a percentage, and a not insignificant percentage in the region of 40 to 50% as described above. Now, to that extent, the judge is going back and looking at what she said at 465 was not the right starting point. And in C, she then looks at Mr. Alexeyev, while originally employed on the salary, expected a percentage participation.
Is she going back, or was she looking at what Mr. Rudhadze had recovered in the ad hoc period?
She's looking at, as I understood, the ad hoc period while he was still working with SCPI. So what I'd meant to mean was, whereas in 465 she says it's the wrong approach to look at the profit share agreement, she then says in 469B, well, actually, let's look at the profit share agreement and use that as the purposes of working out what factors should inform the exercise of this discretion. So there's a tension between what is said in 465 and what's said in 469B.
What is that? 465 is, she's saying, you can't just take what it was agreed, if it was agreed, would be the profit over the course of the whole exploitation of the business opportunity. But if I'm trying to work out what these services are worth, I can look at the fact that he was in fact paid at 50% for this type of work in relation to these type of services. That's not, those are apples and pears, aren't they?
My Lord, with respect, I would say no. What's being said in 465 is one shouldn't look at the enforceable, the agreement as concluded or allegedly concluded, because that is referring to the future. What then is looking in 469B is looking at, to some extent, what was concluded and what was ruled out of impact in 465, but it's also referring to a historic period, not appropriate guide for what would have happened in May 2011. So I say there's 2 elements to it. The first element is the judge is creating a tension between 465 and 469B because she's looking at what Mr. Rudhadze had been agreed to receive, but she's also saying, well, let's look at the past, and it's not an appropriate guide, we would say, when one's looking forward to work out what would be reasonable remuneration in the circumstances of the case. Moreover, both B and C should be based on an allegation of loyalty. But no loyalty was displayed by Mr. Rudhadze, and in relation to Mr. Alexeyev, it's purely an expectation going forward of a participation in some shape or form. So we say that the second and third factors are not factors on which safe reliance can be placed. The fourth factor relates to Mr. Marson, and we say again that's irrelevant. Mr. Marson, during the time that he worked for the revoker, one of the claimants, was that he was paid a salary, and what it's referring to is an expectation of a share of profits that he expected to receive from Mr. Rudhadze and Mr. Alexeyev. only by associating himself with the first and second defendant's breaches of duty was he offered a profit share. So that can't be, we would respectfully submit, an indicator of proper value. It's a real bootstraps argument because it is using what one set of defendants agree with another defendant so as to then justify what all three defendants together say they should be entitled to receive. The fifth indicator over the page on 215 little e relates to Mr. Howe, and that relates to high-level expectations of another individual back in 2008. Mr. Howe was in the frame for undertaking the recovery services in 2008. There was a substantial amount of evidence in relation to him in the phase 1 trial. The crucial issue in relation to Mr. Howe was that he was negotiating with the family at a time when the family was in a position of great weakness. Badri had just died, and the family seemed on the rack. In those circumstances, it's unsurprising that Mr. Howe should seek to claim much larger sums of money than the defendants and Mr. Jaffe thought to be appropriate. And again, if one goes back to look at the phase 1 judgment, one sees the judge looking at the negotiations that took place and the decision made by both Mr. Rudhadze and Mr. Jaffe that Mr. Howe is someone who was no longer acting in Salford's best interests and was not someone who was asking for a fee that should be paid. And the relevant phase 1 judgment references for that are paragraphs 132 to 145, and in relation to the difficulties that the family faced in 2008, it's paragraphs 123 to 126. So what we say is, individually and taken in the round, is that those 5 indicators don't show what would be reasonable and fair remuneration from 2011 onwards. At most, they look at the 2008 period, or 2008 to 2011, Mr. Howe, 2008 in particular. What we say the judge did was to get snippets of evidence and then seek to stitch those snippets together to produce a basis for a finding.
But assuming you can say in relation to E, that looking at what the family might have paid just can't be relevant, because the pot that we're arguing about is what the family has effectively paid. We're looking at what percentage of that or remuneration for obtaining that it would be appropriate to notionally require your clients to pay to the defendants. And that's error, or partial error, that seems to also come in 471, where it says what the family, and then brackets, or SCPI, which seems to be the correct question, is paid. So E, it seems to me, is E. I do see that can't be relevant.
Well, can we be clear? Because one thing is, of course, the account to which this relates is the later deal with the family, isn't it? So the subject matter to which the 25% would attach relates to the return from the family under the later deal.
Yes, but Mr. Howe's deal was with the family and how much he was going to be paid as an individual for providing the recovery services to the family. And I would endorse my Lord Justice Phillips' observation that there is a conceptual difference between that remuneration and the remuneration that someone in the position of SCPI might want to pay other people to conduct the service.
I quite see that, but for example, if you see a profit approach as relevant, then the quantum is driven by reference to what you're getting from the family.
That I accept. And when one then looks at paragraph 471, one sees what the judge ultimately concludes, which is that it's a tens of millions case, Now that might be justified by Mr. House's position that he expected to get tens of millions from providing the services, albeit that actually these defendants are seeking an allowance not from the family but from the person who would have been operating in Mr. House's position. But on any view, how one then gets from tens of millions to 25% in circumstances where the 25% produces a figure of 44 million is entirely unclear.
To put the earlier point another way, we don't need to estimate how much the family would pay because that's a known figure. So analysis of what somebody else might have been paid doesn't help us take it further forward. We know what the family paid roughly, and the question is what percentage of that in this analysis should be paid to the defendants for getting that for SCPI. That's the issue we're engaged in.
Absolutely. And we say the judge's analysis doesn't explain how either tens of millions should be paid by SCPI to the defendants, nor does it explain why 25% is the appropriate rate. What that means is the court has not exercised the discretion by way of exceptional case, by way of sparingly used, and by way of deterrent effect. Because one could read what the judge has done here as saying, well, this is what they would have got in any event. And we say that is not appropriate. It's not appropriate in principle. It's also not appropriate when one comes to work out how much, in fact, they should be entitled to receive. So by way of conclusion on our appeal, we do say that the judge erred. She embarked on a roving commission when she should not have done so. She should have held the defaulting fiduciaries to their election choice as to what case they wanted to bring and prove. Having found that a conscious tactical litigation decision was taken not to advance any positive case on the allowance, the judge should have said that they'd not proved their case, they'd not discharged the onus, and they should receive no equitable allowance at all. The court may think now that that is harsh. We submit it is not. It is simply a proper application of the stringent rule of equity. I finished 10 minutes early. Does the court have any further questions for me?
Not on my part. Thank you. You're going to go next, Mr. Burt.
No, yes, it's me. If I could just have 2 seconds to rearrange the furniture. I'm grateful. As the court knows, and as Lord Wolfson explained yesterday, I'm just going to respond to the claimant's appeal that Mr. Weisselberg has just covered, and then Lord Wolfson will do a reply submission on our appeal. Can I just start with explaining where this fits into the bigger picture? In other words, this point, the equitable allowance at the 25% level held by the judge. That is effectively, in the scale of the whole case, an alternative to ground one of our appeal. In other words, if we were to succeed on ground one and the account was reduced to 50%, we recognise that the judge's equitable allowance could not be sustained in addition to that. So my submissions proceed on the basis, without prejudice to the points made in the defendant's own appeal, that the court is against us on ground one.
That's going further than Mr. Wilson, Lord Wilson was prepared to go on yesterday, is that right?
I'm so sorry.
That goes further than Lord Wilson was prepared to go yesterday.
I think the point that Lord Wilson was dealing with yesterday was the interaction between ground one of our appeal and ground two of our appeal. In other words, the interaction between 50% and delay. Yeah. What I've just said relates to the interaction between our response to the claimant's appeal, namely 25%, the interaction between that and ground one of the appeal, namely 50%. And given the common factors that relate to that,
seems to us unrealistic to say we could reduce it to 50% based on the profit sharing agreement and then said, and we deserve a 25% allowance on top of that as well. And so the court knows where I'm going. I'll just sketch out the order in which I'll address the points. Just first as a preliminary point, I'm going to respond to one of the points made by Mr. Weisselberg yesterday in his overarching section relating to the RBS litigation investment, which needs a little bit of context and correction. That'll be quite brief. And then I'll deal with the points arising on the claimant's appeal as follows. One, something briefly on the nature of the appeal. Two, certain points from the judgment relating to the appeal. Three, something on the authorities on equitable allowance. Four, something on the authorities about pleaded cases and so on. Five, identifying how the case was put by the defendants by way of pleadings, submissions and evidence. Six, dealing with Learned Friend's points about the claimants having somehow been denied an opportunity to put in evidence to deal with the case as it was ultimately found. Seventh, just dealing with the suggestion that the relevant point in time for assessing the value of the defendant's work was May 2011, and somehow profit share agreement or any other factors related to 2008 are either less relevant or not relevant at all. And then lastly, dealing with the five indicators the judge found Mr. Weisselberg criticises. Now that's a longish list, I accept that. I'll do my best to go through it as swiftly as I can, giving references where I can rather than taking the court to documents or authorities that you've already seen. But there will be some things that we'll need to go to. So just briefly dealing with the point made by Mr. Weisselberg about the RBS litigation funding opportunity. And Mr. Weisselberg made this point yesterday, suggesting, I think it was in his list of, these are things you can take from the findings of the court below. He made a point relating to the other investments that the defendants had made, which, as the judge held, fell outside the account. And for your notes, it's at pages 161 and 164 of yesterday's transcript. And he made a comment about the other investments that the defendants had made, and they had made them with varying degrees of success. Just for background, these were called responsive investments at trial, one will have seen in the judgment, for example, because they were investments that fell within the scope of an order compelling disclosure and information provision about certain things. In other words, responsive because they responded to the terms of that order. And the reason why they had to be disclosed was so there was sufficient information to enable an argument to be had about them as to whether they should fall in or fall outside the scope of the account. And Mr. Weisselberg yesterday said that these were very valuable assets, only acquired as a result of the defendants undertaking the recovery services, and that they were assets acquired by the defendants as a result of their breach of fiduciary duties. And then on page 64, he said that the RBS litigation opportunity in particular would not have been obtained but for having the relationship with the family. And so the court knows that's just not a correct exposition of the position in terms of how it was left in closing submissions or indeed by the judge in the judgment. It may have reflected to some extent the case that the claimants were pursuing in opening the case at trial, but it doesn't reflect the findings. The judge found that none of those fell within the account. Now that's because in respect of three of those investments, the claimants abandoned their case about them in their written closing, recognising there weren't sufficient links between those investments and the recovery services. The court can see that in the judgment at paras 199 to 200. In fact, I should also add, maybe we should just quickly turn that up. That's in Core Bundle 1, tab 9, page 159. Where the judge recites...
Do we need to spend a lot of
well,
time on this? This was really a jury point, which is, look how much we haven't claimed for. That we're not operating, it's not operating quite so harshly on the defendants, to which you say, what you haven't claimed for was obviously what you were either abandoned or the judge held you weren't entitled to.
Well, maybe we don't need to spend too much time on it, because it was, I think, as you almost said yesterday as well, a jury point. But the trouble is, there's a fear sometimes that these points land somewhere buried in the deep recesses of the judicial mind.
You can give us the references.
Yeah.
I'm not sure we need to go to them.
Fine. So that was where it was recorded that it was abandoned. In fact, as the evidence at trial showed, a lot of those investments hadn't even increased in value since they'd been acquired. Litigation funding, there was only one that they pursued their case, that was RBS, and the judge, for the reasons she set out, powers 408 to 418, that's pages 204 to 206 in that bundle, she said it just wasn't sufficiently linked to the breaches of duty to fall within the account. And I simply ask, if my lords have any interest in this point at all, to have a look at those reasons. So, for example, the judge found that it was not the case that the idea came to the defendants via a connection to the recovery services. And if one reads that, one will understand, I think, why it simply can't be said that any of those investments are things that have generated funds for the defendants that they wouldn't have generated absent their breach of duty. The only thing one needs to know is that they fall outside the account, and so one can disregard them for today. So insofar as there was a sort of, you can keep in the back of your mind that the defendants have done all right out of this, whatever you find today, that's not a submission that can stand with the judgment. The nature of the appeal. We do say this is a narrow appeal. And it's important to recall, we say, that the claimants are not challenging the judge's decision in principle that the defendants were entitled to an equitable allowance. So if one looks at the grounds of appeal, just so I can explain what I mean by that, that's in the core bundle 1, behind tab 4, and the grounds are pages 81 to 82. What the first ground is about the fact that the actual allowance is awarded on a basis that had not been argued and in support of which there was no evidence put forward. So it's really a process complaint. And then second ground is about it being wrong to base a conclusion on those indicators of value. But I suppose all I'm trying to say at this stage is that there's not an appeal against the judge's decision that in principle on the facts of the case, given, for example, the defendant's conduct or the level of their work, that they were entitled to an equitable allowance. So, for example, the claimants did seek permission to appeal on the basis that the equitable allowance should not have been granted because of the allegations the claimants had made about the defendant's conduct of the case. And they were refused permission on that ground, both by the judge and on paper by, I think it was Lord Justice Males, by this court. And similarly, there has been no attempt to appeal the grant of the allowance on a general legal principle, for example, by saying the judge did not apply the correct legal test for what is required for an allowance. So although there was quite a lot about things like Guinness and Saunders and the need to find exceptionality and a deterrence and so on, that's not a point that features in the appeal notice. If one looks at the paragraphs being challenged in the appeal notice, 438 to 471, that's the part of the judgment that deals with, if you like, the facts as to skill, as to risk, and then the judge's analysis of was there necessary skill to ground the allowance. But what is not challenged is what she has said earlier on in the judgment about the law. So, for example, at paragraph 372, when of the judgment at page 196, having cited Professor Conaglan, where she explains circumstances in which an allowance might be granted for skill in labour put in by the defaulting fiduciary, and so on. That's not a paragraph that's challenged. So we say there isn't an appeal in respect of what is the correct test in law, or what for the circumstances in which an equitable allowance should be granted. It is about, was the judge right to go down the route she went down given the pleadings and the submissions and the evidence, and were the factors she ultimately took into account sufficient to support her ultimate finding as to 25%. Then the second opening point about the nature of the appeal, we've put into the skeleton. I don't think it is really an issue, that the decision on the issue, or at least in most cases, the decision about whether an equitable allowance should be granted and at what level is effectively a matter of what is often termed a discretion of the judge. And that term is used in a number of the cases, including Murad at paragraph 88, Gray in the Court of Appeal at paras 234 and 236, and in the New Zealand Court of Appeal in Churnside at paragraph 140. And obviously, it's not meant like a case management discretion, but a sort of evaluative judgment, recognising that often, usually, the judge is in the best position. Now, I quite accept that if there is a point of principle that something is taken outside a pleading, that has to be dealt with. I can't just stand here and say it was all up to the judge. But it is an important part of the context that has to keep this appeal on the straight and narrow, that there is not a challenge to the exercise of the judge's discretion in that sense. Or if this were able to turn into a challenge to, was the judge right to alight on 25% if the pleadings and the evidence are okay, one has to meet the normal stringent requirements of this court interfering with the exercise of a judge's discretion. And we've cited the Privy Council case in Ming Siu Hung at Authorities for tab 30. I'm not going to go to it. The principles are well known by this court. They're set out in paras 20 to 23. And they also include well-known propositions such as the one at paragraph 28.3, that matters of the weight of evidence are also points for the judge, not for this court, absent irrationality.
I thought Mr. Weisenberg did say very clearly that he was challenging any discretionary elements on recognised grounds of error of principle or taking into account irrelevant factors.
Yes, and
that is a challenge.
Well, I accept that insofar as it is a point of principle, in other words, not pleaded, therefore the judge shouldn't have found it, then that is the challenge that I have to meet.
Well, and irrelevant factors.
Well, insofar as that amounts to, yes, if she's taken into account, if you like, all irrelevant factors, or an irrelevant factor which is causes the decision to be wrong, within the normal rules about challenging a discretion, I accept that. But if one is left in the situation where, well, there's material in what she found, in those 5 indicators, say for the sake of argument at this stage, well, we can see there might be a little problem with this one, and we're not sure about that one, but that on what's left, it was a perfectly rational decision. It's not up to this court then to say, well, if we'd been in her position, we think 25% is a bit wrong.
No, but 4-5 are dodgy.
No. I'm not saying that ground 2 of his appeal is not open to my learned friend. Can I briefly just identify some points from the judgment, which I'd like to underline, some of which might otherwise get lost because the judgment is lengthy and we're covering quite a lot of ground. But some of them we've been, if not through in detail, at least passed at speed already over the last couple of days. So it may to an extent be a page-turning exercise. But first of all, can I just invite my lords just to look very briefly. This is in the Core Bundle 1, tab 9, where the judgment is. Page 149. Para 122. The judge records the common ground that the defendants did a huge amount of detailed work on the recovery services. She notes there's an issue as to skill and risk, but nobody doubts that they worked extremely hard. And quite a lot of the sections of the judgment reciting the chronology, both before this and after this, go through a lot of what was done. I'm not going to go through that in detail. I'm simply going to point out to your lordships that it's there and there was a lot done. And part of the reason for doing that is because it'll feed into a submission I'm going to have to deal with later about the submission against me being effectively, really by May 2011, most of the hard work was already done, and all the defendants had to do was pick up the fruit. I think that was a submission the judge directly rejected. But so the court knows, before 122, we've got the section on the IRSA that we've spent some time looking at. Before that, there's a factual section about what the defendants did between May 2011 and October 2012, which is interleaved with some other parts of the chronology as well. It's not all about the defendants' work. But then one moves from 122 forwards, dealing with, nearly all dealing there with what the defendants then did in relation to recovery services over the course of the period up to 2017. And there's various paragraphs detailing the work. I won't go through them all. Some of them, such as 139, specifically talk about the considerable work on the parts of the defendants. Others just narrate what was going on. And most of it in this section is to do with the defendants' work. There's the occasional reference to things to do with Mr. Jaffe, but mainly it's the defendants' work. And then, as my lordship, as the court knows, the recovery services carried on throughout this whole period, as the judgment records, 2014, and then onwards beyond that, up to the execution of the deed of termination, which comes into the judgment at paragraph 180. Other things are mixed into the chronology, but quite a lot of that is about the defendants working on the recovery services. And we say that even a brief perusal of that shows that there was substantial and significant work that still had to be done and was done by the defendants on the recovery services in the post-breach period. And as Lord Wolfson has already explained and may come back to in reply, it was hard work with, at the start of that period, no firm contractual arrangements in for remuneration, and indeed even after the IRSA, no guarantee of financial remuneration because of the threshold, the carry threshold that had to be reached for the real money. The claimants, and Mr. Vice went to this today as well, on this same theme, went to page 202, paragraph 402, to suggest that, I think, I can't remember quite how to put it, but that things were set fair, really, by May 2011. But that paragraph should be seen in the context of the section that it is positioned in. And what that deals with is the section starting at paragraph 394 on page 200, which is a section entitled Transformation of the Opportunity. Now, to give the court just the context for that, that was an argument that was run by the defendants at the Phase 2 trial in an attempt to argue that profits earned later on were insufficiently connected to the opportunity as it had been in May 2011. In other words, the opportunity had been so transformed it wasn't really still the same thing, so that there came a point when the profits should fall outside the account. And that argument failed, and that is what the judge is dealing with here. And what the judge here held, that what happened with the recovery services after the breach was effectively a natural continuation of the work that was being done before. That was her finding in rejecting the defendant's case, that there had been a fundamental transformation in the type of work or the areas of work. What she didn't say anywhere was that there wasn't still a lot to do. And one has to see 402, first of all in its context, but also in its terms. And the only thing it's talking about there was that the areas of work were either set fair or well set up for future resolution. In other words, the tram lines were set down, but there was still a long way to travel along them. She says, indeed, in this very paragraph, Mr. Jaffe's view was that everything had been sorted out on his watch, so that all the defendants had simply been left to pluck the ripe fruit was something of an overstatement. But then she goes on to say the areas are set fair. So in other words, the transformation case failed, but she's not saying anything about the amount of work that still remained to be done. And she comes back to this similar fruit analogy later on in the judgment. We've already looked, Mr. Weisberg's already taken you to the parts of the judgment which deal with the judge's decision on equitable allowance. I don't need to go through those in detail at this stage. We may have to come back to them later. But we do note that what the judge found at paragraphs 456 and following, that's page 212 and so on, where she explained her various findings about the work and the requisite skill, in terms of those as findings of fact are not challenged. I think Mr. Weisselberg confirmed that today. The conclusion she draws from them in terms of where it gets to, I accept is the matter for argument. And just to complete the point I started earlier, 457 is the return of her confirmation that everything had not been sorted out by 2011. She was not persuaded, she said, by the claimant's characterisation that everything had been done and that all remained was to pick up the fruit as it dropped from the tree. Much had been done, it was true. But one can test it this way, she said. Could the family simply have proceeded without help? The answer to this is plainly no. This was never contemplated by them, the defendants, or by Mr. Jaffe. The judge then went on, having set out the facts, the skills demonstrated, concluding they weren't unique skills, but they were valuable. And just from the court's note, she refers specifically to Mr. Rudhadze and Mr. Alexiev. Elsewhere in her judgment, she refers to Mr. Marson and his particular skills. That's at paragraph 202. 220 of the judgment at page 163, where she described his skills as including a facilitator, day-to-day manager, liaison. She said effectively he was like a junior officer. That's how she ended up describing him. And then we move to the part of the judgment at 466 and following, which I'll come back to, which is really the part that is challenged. Just in passing, I note where the judge recorded at paragraph 465 that the defendants advocated a 40% allowance. That reflects what Mr. Cogley said in closing submissions, which Lord Wolfson dealt with in his submissions, and I won't go back on. But the defendant's case was a 50% allowance. And we'll look at, I'll take my Lord O'Sullivan briefly. It'll be tomorrow now, I think. But we say that when she says at 466, and then again at 470, she was, if you like, going down the O'Sullivan and Boardman route. I mean, it's right to say that in both of those cases, the court concluded that there needed to be further inquiry as to how the allowance should be calculated. But we say that that doesn't really take you anywhere, because that's then what she goes on to do. To make what she really means by following that is recognising what was said in O'Sullivan, that, and we'll go to the judgment, about there being a reasonable remuneration, but people shouldn't get as much as perhaps they might otherwise have got. And that is the broad brush approach amongst the other factors that we'll come to that she follows. And we say she was, in broad terms, right to come to the view that there should be an equitable allowance. And, as I say, in the alternative to our own ground of appeal, say she was right to come to 25%. And she was in the best position to assess what was an appropriate percentage given all the circumstances of the case, given that she, more than anybody, has been steeped in this litigation, having heard 2 lengthy trials and delivered 2 lengthy judgments, as well as a number of the interlocutories. And one does have to pause and say, what would be the position if no allowance had been awarded, given the judge's findings that they had dedicated a lot of hard work over a long period of time to not give them any allowance at all, as is the claimant's case. We say would have obviously been entirely unfair, inequitable, and would not have reflected any of the authorities, and we'll come on to look at some of those tomorrow. The judge clearly did not want to reach that conclusion, and she was clearly right not to want to go there. I've gone past 4:15.
Well, we might go on a little longer. Can you just remind us what the estimates are for everybody? How much longer do you think you've got?
On the agreed timetable, I had 1 hour and 50 minutes, and I had about 25. I can't quite remember when I started. So I think I'm going to probably have that, and unless there's particular points I should take more likely.
Lord Wolfson was going to have, I can't remember what his reply was.
My lords, we have 50 minutes on the timetable, but I wouldn't anticipate using all of it. It will be a reply, not a repeat sufficient.
Right. And then I think 20 minutes wasn't it for Mr. Weisselberg. Well, why don't we go on for another 15 minutes or so? You happy with that?
And just before leaving this section of the judgment, we ought to note that the judge here does not say she's looking for, quotes, market value, close quotes. In the claimant's written submissions, the phrase market value took on a slight air of a term of art, as though that was the thing that the judge had said she was looking for, and almost the very thing that the defendants hadn't put in any evidence of. And I suggest that they wanted the focus to be on that because it resonates with the idea of having expert evidence. And there wasn't any expert evidence. But actually, the judge doesn't refer to market value. What she's referring to is the value of the services. Now, in a sense, you may say, is that a distinction with a real difference? But the point I'm making is one shouldn't get too tied up on the label here. What the judge was looking for was the approximate value for a reasonable remuneration in all the circumstances of the case. And that was the right approach to follow. And there may be cases where having expert evidence of market value is valuable as to that. There may be cases where it is pointless. And in a case like this, one may ask oneself, what is the relevant market? As in any case, it may depend how narrowly or how wide you go. But there's absolutely no rule that says you have to establish value by reference to expert evidence. And it may well be, indeed almost certainly is in this case, that the best evidence is not expert evidence, but it is evidence that the parties to this case, the evidence of the agreement or the arrangements that the parties to this case came to as to what the services were worth. And I'll come to that point in a short while, but one has to read the claimant submissions really with that in mind, because market value as a phrase is not up there in lights in the way that some of their submissions suggest it was.
What's the real difference between value and market value?
No, well, no, and I'm not seeking to draw that distinction. I mean, as I said, what the judge was trying to identify was what was the reasonable remuneration, and that is obviously based on what was the value of their services. But all I'm trying to get away from is the idea that inevitably one has to have expert evidence in order to conduct that inquiry. We say
certainly
you don't.
It would be one way to assess it.
It would be one way, yes. Well, it might be one way in the right case if one can convince the court that there is a sufficient body of expertise who can give evidence of a relevant market. But one wonders if we'd gone along to the judge at an interlocutory in this case, having already had permission for 4 or 5 experts, or four experts on each side of valuation forensic accounting, to say we'd also like an expert who can tell us what the market is for carving up the division of profits from recovery services between someone in Mr. Jaffe's position and someone in the defendant's position. I think we may have been met with short shrift, but that was never tested by either side. It could have been by either side. There's nothing in the way of parties dealing with that sort of evidence through the facts, as happened in this case. Moving on to some of the authorities. Looked briefly at O'Sullivan, but I wonder if we can just go back to it, please, briefly. It's in Authorities 1, behind tab 11. And the relevant passage is at page 468. It's in the judgment of Lord Justice Fox. And he begins at this page on the second line by referring to the fact that a hard and fast rule that a beneficiary can demand the whole profit without an allowance of the work which it could not have been without which it could not have been created is unduly severe. Nor do I think the principle is only applicable in cases where the personal conduct of the fiduciary cannot be criticised. I think that the justice of the individual case must be considered on the facts of the case. And we do underline that. One can't look too hard for hard and fast rules in this area. There is a lot to be said for each case having to turn on its own facts. At letter C, Lord Justice Fox rejects the proposition that what the court should be aiming to do is to put the defendants in a position in which they would have been in if the agreements had been on the basis that might reasonably have been negotiated with independent advice. He rejected the evidence of an expert witness on that basis. It's not that sort of hypothetical exercise. The relevant question is, what recompense in the circumstances of this case would it be reasonable to allow? And that, we say, must be, at least potentially, a multifaceted inquiry, not necessarily dependent on one single measure or input, but can take into account all of the circumstances. And it goes on further down the page, at E and following, to confirm that in principle awarding the defendant part of the profit is permissible, if that is what justice as between the parties demands. And then at the foot of the page, the court, having ordered an allowance, ordered an inquiry for that purpose. And turning over the page, B, the guideline laid down for the account included that the allowance would not take, it would take account of the contribution made by the defendants to Mr. O'Sullivan's success, but it would not take full account of it, in that the allowance would not be at all as much as defendants might have obtained if the contracts had been properly negotiated between fully advised parties. So it won't take full account of the value of the contribution, but it would be taken into account in a substantial way. Now, we've identified in our skeleton argument some cases where the court has fashioned an appropriate allowance based at least in part on the arrangements between the parties, where those have sometimes included a profit share. And can we just look briefly at a couple of those? They are all first instance decisions, so one may think there is limited I can get out of them in terms of guiding principle, but they do demonstrate how in practice the courts deal with assessing the value to be given to an equitable allowance, and they certainly haven't been met with howls of protest. The first case briefly to look at is Nottingham University and Official, which is in Authorities 2 behind tab 14, decision of Mr. Justice Elias. This was a case where the defendant, who was employed by the claimant university, he was a clinical embryologist, and the defendant was held to have breached his duties to the university by arranging for his subordinates to provide services to third parties at clinics overseas. And those overseas clinics paid the defendant, Dr. Official, who in turn remunerated his subordinates, but retained a profit for himself. And he was held to have breached his fiduciary duty in arranging that work. It was also said he breached his fiduciary duty in doing it himself, but that wasn't made out. The breach that was made out was arranging work for others and making a profit out of it. And at page 421 of the bundle, towards the end of the judgment, once the questions of liability have been dealt with, the judge considers equitable allowance, and having considered, starting at D, the various well-known authorities, Phillips and Boardman, Warman, Guinness and Saunders, and running through, including details of Guinness, he concludes at the next page, 422 of the bundle, that it would be right for him to have an allowance. And how he calculates that allowance, we say, is noteworthy. He says, first of all, any sum awarded must be equitable in all circumstances. A crucial feature of this case is that Dr. Official was drawing his university salary whilst doing this work, and indeed contends it was an acceptable way of performing his duties. If he had received payment in accordance with his contract, he would have received 5% of the income received from these patients, save that after a renegotiated contract, he would have received nothing because the cap was apparently reached. I consider that it would be equitable toward that sum in this case. And then he says how that works its way out in the next paragraph. But what we say that shows is that there was an existing profit-sharing agreement between him and his employer from patients who he, or for certain work he did within the scope of his employment, tune of 5% of a profit share, leaving the cap to one side for a minute. And the court used that as the basis for working out what his equitable allowance would be on the work that he had done in breach of his fiduciary duties, and notwithstanding it was in breach of his fiduciary duties and outside that contract, the basis for his equitable allowance was the same 5% as he would have been awarded had it been within his contract. So that is an example both of the court awarding an allowance in a percentage of the profits otherwise payable under the account, and also of using the arrangements that existed between the parties to identify a suitable percentage. Lord, the other case we rely upon in a similar vein is Kingsley and Mackintosh. We've noted the relevant passages in our skeleton at paragraph 16. Trying to go a bit quickly, I won't take up time by going to it, but that is another case that involved the diversion of a business opportunity. There had been a previous agreement that the defendant director was entitled to reasonable drawings of £3,000 a month, which, after he had resigned from the company, those payments ceased. But the court concluded that that demonstrated the quantum of the allowance, even after resignation, for the profits he'd made in relation to business he'd diverted to himself to pursue post-resignation. So again, we say another example of the court awarding allowance based on arrangements between the parties, in that case arrangements which had been agreed but had ceased by the time of the profits that were being accounted for. And in neither of those cases was there expert evidence as to market rates or anything else. The court was, we say quite sensibly, using the best available evidence, which is what the parties between themselves had worked out what the services in question were worth. If I could just turn up the other case we rely on in a similar vein, but if my Lord wants to rise now...
Why don't we finish this off, yes.
Which is Akidia and Dickinson, and that is in Authorities 2, tab 21. The decision of Mr. Justice Voss. It was a case that dealt with the sale of a valuable drawing where the transaction was concluded through a chain of two agents. The buyer was paying one price, but the seller understood that it was receiving a lower price. And the difference between the two prices had effectively been retained, subject to some payments out, by the second agent, Dickinson, and the seller sought payment to it of the profit made by the second agent, Dickinson. So, a fact pattern which isn't unknown to courts in this jurisdiction. The judge concluded that Dickinson was liable to account as an agent or fiduciary for that undisclosed commission, and most of the judgment deals with various issues that went to liability, but also then with whether an allowance should be made for the defendant's work, and that was dealt with at paragraph 95, which is page 641 of the bundle. Just in reading this, so the court knows who everybody is, because I've skipped over the rest of the judgment. Akidia is the seller acting through Mrs. Sackler, and LAL was the first agent acting through Miss Luxembourg. Dickinson was the defendant's second agent acting through, I think, Mr. Dickinson and a Miss Ward, although she doesn't crop up in this paragraph. And the buyer is just unidentified, so it's just the buyer. But this is what Mr. Justice Voss found in this case. He found, taking all the matters into account, my findings from the evidence, it would be just and equitable in my judgment for Akidia, the sale, to pay, in other words, to pay in commission or to pay by way of reasonable remuneration as equitable allowance, what it would have paid had it known that the agent Dickinson had achieved 7 million for the drawing rather than the 6 million it thought. And one cannot be sure, of course, what precisely would have been negotiated, particularly because Mr. Flint didn't cross-examine Mrs. Sackler, who was Akidia's agent, on this point. But I have formed the view on the evidence I have heard that Akidia would have been unwilling to pay more than one commission of 10% of the gross sale price. And that seems to me to be the usual kind of figure expected in this market. Certainly it was close to the figure that the experienced Miss Luxembourg negotiated, she being the other agent. Had Akidia been informed of the sale price of 7 million, I would expect that Mrs. Sacker would have told Miss Luxembourg that Equity would pay 10%, and that should be split. And then he works out how that works on the facts of this case. LAL and Miss Luxembourg haven't been brought before the court, but he says that doesn't affect anything. So he concludes that the commission should be 10%, namely $700,000, from which he deducts the commission already paid to LAL, therefore leaving $200,000, if you like, commission that can be retained. In other words, that was the figure for a reasonable remuneration or allowance. So what this is an example of a case where the allowance is being assessed by reference to what the agent was likely to have received had the principal known all of the facts. But it also appears to be an example of the judge working out an appropriate allowance without necessarily being bound by how it had been put by the parties. Now, we don't have the pleadings, so we can't be sure how it was put. But there is no suggestion here that the judge was identifying the allowance he ultimately awarded as being the precise case pleaded by either one party or the other. He appears to be doing it on his own initiative, taking into account all the facts and circumstances. And really the reason I say this is because in this paragraph we can see that the case he ends up with was not something put to the key witness. And so one assumes that if it was a case that was actually being positively run, it would have been. So we say this is a good example of a judge dealing with the facts without being unduly trammelled in the case of equitable allowance by precision or in a pleaded case, or necessarily saying if it's not precisely pleaded in this way I can't go there. He has, as the judge put it in her judgment in our case, a more robust view of things than that. That's probably, I know I've gone on even longer than my lord let me, but it would be.
Right, 10:30 to